We're excited that you could be here tonight. We're continuing our series on educating you on the most important things that you need to know to start your business and succeed. We're excited tonight to have Mr. Peretz Bronstien, esteemed attorney and business litigator, Harvard graduate, who's going to come and he's going to share with us the most important things that you need to know in terms of legal considerations as you start your new endeavor. Peretz.
Thank you, Rabbi Wordy.
Oh, yeah.
Thank you for having me. Good evening, everybody. I meet many businessmen that have good ideas, and they have a concept that they begin to develop. But it's essential that you have the legal fundamentals in place, because without the legal fundamentals, the business does not have a solid footing. And I see that as a litigator, which means I help people resolve business disputes. What happens when businessmen and businesswomen don't have the legal fundamentals in place? So I'd like to go through some of them with you. I have 10 points here, and you'll keep them in mind, and hopefully you'll never need a litigator, you'll just make money in your business. The first thing is you have to choose a name. And two things you have to do. On the state of New York, you just go to the New York Department of State website. You can input a name, any business name, and it will tell you whether somebody is using that name already, whether it's an LLC or a corporation. And if somebody is, then you can't use the name. But if someone is not using it, then that's one hurdle. Clearing the name. The other thing you have to make sure is, even if it's not used as the name of a corporation officially, if it's used in business, that particular name or logo or slogan, then someone else may already have trademark rights on the name. Trademark rights means the first person to use a particular word or phrase or logo in association with a particular type of business owns the rights to use that name. So, and you can, the easiest thing to do is you go to the New York Patent and Trademark, the United States Patent and Trademark website, and there you can do a search as well and see whether, when you put in a word, and anyone else that has any kind of trademark similar to that, using that name or phrase, will come up, and you can actually do a search for logos, images as well. So that's the first thing you have to do. Clear the New York State and trademark freedom of the name before you use it. Because if not, then somebody can come and stop you from using it because it's a trademark infringement. Then you have to choose the type of entity. You can do business just as a sole proprietor. You don't create a legal entity, you just do business as yourself or two people together as partners, and you can use a business name. You have to file with the county a assumed name certificate. You have to tell the world that name is you, and you don't have to form a corporation or an LLC. The problem is, then you have personal liability. It means if there's a contract that you enter into as a business and there's a breach of, let's say you can't pay your lease, or that's really many small businesses, their big financial problem is paying the lease, then you have personal liability on the lease. If there's no corporation, no LLC. So I would advise that in almost all instances, it makes sense even to form an LLC or a corporation. By the way, a partnership as well. If you're doing business as just Chaim and Yankel together as partners, and they haven't created an entity, an LLC or a corporation, they're personally liable for if somebody slips and falls, or don't pay the lease, or breach a contract with a vendor. It's personal liability, so I recommend that you form an entity, an LLC or a corporation. I won't get into all the details, but in general I would say that nowadays there's no reason for a small business to create a corporation. I would recommend that almost always you form an LLC because it's more flexible than a corporation. In terms of taxation, there are less restrictions to avoid corporate tax. You can avoid corporate tax with a corporation as well if you become an S corporation. But to be an S corporation, you have to have all kinds of rules, how many shareholders you can have, and you can't have a corporation as a shareholder. So you're better off forming an LLC. Unless you're ready to go public, you're planning to do a public offering on the stock market imminently, I would recommend almost everyone forms an LLC. And an LLC basically means you have now an entity, a separate unit, business unit, that when you do business, you're doing business through that LLC. So the contract will be in the name of the LLC. If you enter into a vendor contract, and if there's a breach of contract, if you can't pay the money, then the LLC owes the money, not you personally. Now, when you form an LLC, you have to decide who are the owners of an LLC are called the members. Who are the members of the LLC? If you form a corporation, the same as a shareholder of a corporation, similarly the members of the LLC. The other thing you have to decide are who are the managers of the LLC. Among the it's usually among the members, some of the members are the managing members and some are not. Similarly, in a corporation, you have shareholders, and usually among the shareholders, it doesn't have to be from the shareholders, you have officers and directors managing the corporation. I just had yesterday, a couple of brothers came to me that the grandfather passed away and started a business, and all three of these, and then he left it to his wife when he passed away. She ran the business, and together with her three sons. The corporate book of this corporation was never filled out. There's nothing in writing to indicate who owns the corporation. They report to the IRS. You have to do a K-1 on your tax return. Who owns the corporation? Who are the shareholders? They reported it one way. The SEC, they reported it in another way. Everywhere, it's a big mess. So what they didn't do is what I recommend you do is when you form your corporation or your LLC, you fill out the corporate book or the LLC book, identifying who are the shareholders, who are the managers, so you don't have to, God forbid, have litigation down the road. When this particular corporation I'm talking about is, the reason it's relevant now is they own this old warehouse that was not worth very much money. It's on the waterfront in Brooklyn, and now it's worth tens of millions of dollars. So now they got to figure out who owns it. In order to protect yourself, I mentioned that a corporation or LLC protects you from personal liability. You have to do what's known as respect the corporate formalities. What does that mean? Again, you have to fill out the book, and it has to be clear who the managers and the members are. Also, though, you have to have a separate bank account for the business, and you shouldn't pay personal expenses out of the business, and you shouldn't pay your business expenses out of your personal bank account. The reason why it's important to be very careful about that is, let's say the business owes somebody money and doesn't pay, and then you get sued. And the business has no assets. Typically, small corporations don't have very many assets, so they say, okay, let me go after the owner, the shareholder. And one of the arguments that can be made is there has been a lack of attentiveness to the corporate form, and money has been passing into the corporation, out of the corporation, and it's not business expenses, but personal expenses, and there's been a lack of formality. Then they can try to do what's known as pierce the corporate veil, which means the court will ignore the corporation and say it's all really the personal piggy bank of the shareholder, and hold the shareholder personally liable for the obligations of the corporation. To avoid that, you have to be careful with your QuickBooks, and any money that you want for yourself personally out of the company, take it as a distribution, and don't just treat it as your own personal piggy bank. Now we'll move on to employees. You have your business, it's set up, your LLC, you've identified the members. The members should have among themselves a management agreement or a shareholders agreement if it's a corporation, and you're hiring your first employee. What should you keep in mind when you hire your first employee? First of all, in companies that I've been the general counsel of, and I've been general counsel of many corporations as advisor, you should have a non-disclosure agreement and non-compete agreement with every employee. It's not a big deal. It's like a 3-page agreement. It basically just says they're going to keep all the confidences, all the business formulas, all the code, all the, everything behind. Today it's all on the web, everything behind the website confidential, and not going to compete. They're not going to, during the time they're with the company and for 2 years after, typically 2 years, 3 years you can get away with. You can't make it too long. And it has to be in the same geographic area, but if it's a national web business, so it could really be nationwide, they won't compete. You don't want to hire the guy, train him, he learns everything about your business in and out, then he'll take all your intellectual property and compete with you. So you have everybody sign a non-disclosure, non-compete. You should be attentive to whether somebody's an at-will as a independent contractor or an employee. Independent contractor means somebody who usually doesn't work on the premises, or if he does work on the premises, he or she has control over their own hours. They're not told what to do. They're given a project, they do it on their own when they want to do it. Somebody who is more under your control, that person usually can be called an independent contractor. Somebody who's an employee is somebody who sits in your premises, you control their hours, you direct what they do. Why is it an important distinction? One of the most important distinctions is overtime. Somebody who's an employee is entitled to get overtime. And somebody who's an independent contractor is not. And there have been a number of class actions. FedEx had one, for instance, that whether FedEx drivers are independent contractors or not. The drivers brought a class action that they're entitled to overtime. And we're talking about, this could, $1 billion lawsuit. And they say they're employees, and the company said, no, you're independent contractors, you're not entitled to overtime. I know, unfortunately, in our own community, there's a heavy-duty lawsuit going on against a small business that had employees that were independent and got tips, and they're suing now for overtime. So anyway, you have to make sure you speak to an accountant and determine whether each person working for you is an employee or an independent contractor, and those who are entitled to overtime, make sure they don't work more than 35 or 40 hours a week, or pay them the overtime. If not, you can have a serious problem. Even if it's not, the overtime is not that much, the statute provides that you can get legal fees. The plaintiff's lawyer can, he can have $100,000, even if it's $20,000 in overtime that wasn't paid, they can get $100,000 in legal fees. So be careful about paying overtime. In general, it's important to have good written contracts. Some of the important terms to have in your vendor contracts is limitation of liability. That if you can put in there that you're not liable for if there are damages more than the amount of money that the customer paid for the product, but that they can't sue for lost profits or any large damages. You can limit damages. Another common provision that protects businesses from lawsuits is that put in the contracts arbitration clauses that any disputes can only be brought on an individual basis, no class actions, and in arbitration, which is typically cheaper than litigation. And the last point I just want to make is it's important to, my partner once said to me, if clients realized how much money they save by spending a little money on legal protection, which will prevent litigation, because $1,000 or $2,000 or $3,000 you'll spend getting a good advisor in the beginning, setting you up properly, and maybe $1,000 a month or $500 a month over time, just to make sure that everything is, everything is legally kosher. You can, if you avoid one litigation, you've saved thousands and thousands of dollars. You can't even get started with the litigation without giving a $5,000 or $10,000 retainer to a lawyer, and then the clock runs at $5,000, $10,000 a month. And so it's very important to choose a lawyer you trust and you like, to be looking over everything that's going on in your business on an ongoing basis, to make sure everything is legal and in compliance, and then you'll be successful and avoid any problems, and God willing, make a lot of money.